31/7.
28/7/23 passed by the Special Judge Majuli in special case number 47/2023, by which the appellant has been convicted under Section 6 of the POCSO Act. Full stop. Ms. Admit the appeal, call for the LCR. Ms. El Jahan accepts notice on behalf of
Respond number
state.
1. Yes.
Respond number 1. Full stop. Next slide. The service of copy of the appeal should be made to the respondent number 2. Who is the, no, to the,
Yes,
to the victim slash guardian, to the
He
victim slash guardian of the victim,
is the father, perhaps.
through the,
Younger sister, so he's the brother.
through the IO slash OC of the concerned police station.
Through the registry then. Because the judgment says that they have.
Put your name down.
That is your law. It is the appeal lordship against the imperial judgment and order dated 38/2023, wherein the appellant was.
Okay, right. Heard Mr. Ardhat, learned counsel for the appellant, who submits that the judgment dated 30/08/2023 passed by the Sessions Judge cum Special Judge POCSO, Kamrup M. Guwahati, in Sessions case number 976/2019, by which the appellant has been convicted under Section 6 of the POCSO Act, should be set aside. Admit the appeal, call for the LCR. Issue notice to the respondents, Ms. B. Buyan, additional PP, accepts notice on behalf of the state. Ms. What?
P. Bora.
P. Bora, accept notice on behalf of the state. Next para, you write. The petitioner shall take steps for service of notice upon the respondent number 2 by submitting a hard copy as well as a soft copy of the appeal petition before the registry of this, to the registry of this court. The registry shall thereafter furnish the same to the additional PP, who shall further submit it to the IO slash OC of the concerned police station, who shall serve the same to the victim slash guardian of the victim.
There is an IL lordship.
Full stop. The report should thereafter be made by the IO slash OC of the concerned police station with regard to service of the notice. Full stop. This is the matter after 4 weeks. Then in the IA, and you write Ms. B. Buyan, additional PP is granted 4 weeks time to file written objection to the application under section 89P. Yeah.
Give you.
See. They have mentioned the wrong provision. Heard Mr. L.R. Mazumdar, learned counsel for the appellant. This appeal has been filed against the judgment dated 7/8/2023 passed by the Sessions Judge Karimganj in Sessions case number 63 of 2016, by which the appellant has been convicted under 148/49, does this say 148/324/307/302 1/149 IPC and section 25(1) capital A bracket close and 27(1) of the Arms Act. Admit the appeal, call for the LCR. Ms. B. Buyan, additional PP, appears for the state, list the matter after 4 weeks.
All right.
Then in the IA, you write, Ms. B. Buyan, 4 weeks again. So you have got the paper book, madam?
No ship.
Where is the thing?
Yes, sir. Don't have to take it on there, sir.
Appellant.
Yes, sir. She wasn't working the morning for her to. Yes.
This is with regard to. This is with regard to what? 302?
Oh, no.
302, yes. 302. Paper book has been furnished to S. Jahan. Paper book is prepared has been verified. Received paper book for the FLN, Sanchita Roy. Okay, right. As per office note dated 19/6/23. Miss Sanchita Roy. Learned Legal Aid Council has received the paper book. Ms. B. Buyan, additional PP also submits that paper book has been received. Accordingly, place this matter for hearing in usual course.
Sir, I was for item number 9, also we have already given back the brief, my lord.
Huh?
We have already given back the brief, lord. So they will engage some other council, my lord.
You have given back the brief to whom?
The client, my lord.
To my knowledge, one Tropon Dairy will appear in this matter. I
So
inquired.
can he,
yesterday,
can you tell him to come?
But then Tropon's number you have not shown. Perhaps they have not filed their
They
wakalat
have
number
not
as
filed
of date.
Now what to
Raju
do?
Nath.
Okay, right. What is your name?
Deborah, my lord. And for item number 9, my lord.
Your name is Deborah.
Deborah, my lord.
What about NJ Das?
Yes,
They are from the same chamber.
same chamber, my
NJ Das, PK Das, A Chowdhury, N Mahajan,
yes,
all same chamber.
yes,
So all of y'all are not appearing.
no, my lord.
There is one analogous matter, item 10, NK Kolita appears in that matter. He came in the morning, he said he'll be here, I don't know.
Analogous matter?
Dinku Das is along with
Okay,
Raju.
okay. NK Kalita,
Hmm.
D Dekha.
He-
Now none of them are here. What to do?
The NK Kolita was here in the morning, perhaps he don't. No bother.
Okay, right. Mr. D Bora, counsel for the FLN in criminal appeal 140/2022 submits that the counsels for the appellant Raju Nath, that is Mr. A Chowdhury, PK Das, NJ Das, N Mahajan and himself would not be appearing for the appellant Raju Nath as Raju Nath has engaged somebody else. He also submits that the concerned file has been returned back to Mr. Raju Nath. Have you informed the registry?
That needs to be done.
Good stuff. Mr. D Bora is instructed to, no, Mr. D Bora is to inform the registry with regard to the fact that the above counsels will not be appearing for Mr. Raju Nath any longer by submitting an application to that effect.
Normally, what happens if the client wants to engage someone else? That other counsel of advocate takes a no objection certificate
Correct,
and
correct,
appears.
correct.
In
But,
that case, I think registry is not concerned.
no, no, but
required-
they have got to be informed.
Yes, that's.
Registry has to be informed. Because then only the thing,
Yes,
you
they
know,
will
then
again.
they can be stuck off from the policy. Full stop. Thereafter, the names of the above counsel may be struck off as counsels for Raju Nath. For the appellant Raju Nath. Full stop. However, no one appears
Okay. Oh.
on behalf of the appellant Raju Nath except for Mr. D Bora, who has made the above submission. Full stop. No one appears for the appellant in the analogous case, that is criminal appeal 141/2022. Ms. S. Jahan, additional PP appears for the state. In view of the real state above, the Before that, it is say, it is also noticed that paper book has been made in this case. In view of in view of there being no representation on behalf of the appellants, leaves the matter after 2 weeks.
Not. 2 weeks is.
Obvious.
Paper book, I think, there is no translation of the paper book.
No, paper book is here.
That's it.
You have not got.
No, I have one.
Let us see if you have got or not.
Yes, yes, sir. The SMS version is also
Paper
there.
book has been furnished upon with.
Lordship, lordship, yes. Oh, lordship, yes.
Really.
So more objection from Ajit. I agree with it. Objection is not. Oh.
Yeah, Lordship, this interlocutory application has come up for consideration of this bail pay and suspension of sentence. Here, three appellants are before your Lordship. I am representing item number 11, Ibrahim Ali.
Ibrahim Ali.
He is convicted under section 302, rest are Lordship, for lesser sentence and they are already on bail. I think.
I'm appearing for item number 12.
What is your name? What is your name?
Kiwi Ahmed. Party Ayub Khan. Petitioner Ayub Khan.
So, yeah, anything, what are you paid for?
They are only connected with my case.
The main appeal.
No, they are.
They are already on bail.
Yes, ma'am. I'm for Lordship, item number 13, Dr. Islam, my name is B. Chaudhary Lordship. Yeah, Lordship, we are convicted under 379 and 34 Lordship. We are granted increased bail Lordship and our case was fixed for hearing Lordship. That was dealt by the single bench Lordship. Since we are connected with that main appellant Lordship, this case was taken up.
So anyway, so what about this criminal what is IA 393?
Yes. 393. Connected with Ayub.
393 is,
Already bail, my lord.
they are.
But you said that they already granted bail.
No, in IA criminal 473 of that is pending, 473.
Huh?
473. IA
Item IA is 473.
473.
There is one IA 393 also.
That is for granting previous bail. They are already.
So why is this matter here? Give me IA 393. Why
It's pending,
should it-
otherwise.
Huh?
It's pending, it should have been closed then.
Yes. Heard Mr. MK Hussain, the council also with the suspension.
This is also single motion. It was single motion. Ayub was single motion.
In the single, before the single judge, was the sentence suspended?
This is what they are saying
Suspended. Sentence suspended.
in Ayub Khan also.
But in out here, there is. Wait a minute, huh? Already on bail. He's already on bail. You're already on bail.
Yes, ma'am.
So why is this application made for suspension of sentence? Why?
Because they have to obtain a bail order from the affiliate court.
Okay.
There has to be an order by the High Court. that
But then
comes-
he has already, but then he has been given bail.
Yes, Lordship, that is because I am on previous bail, Lordship. That's why my bail was continued. But it's 379 conviction, Lordship, 3 years imprisonment, Lordship. Court has allowed me to go on previous bail.
Or till disposal of the appeal or something?
Yes.
That is how his eye is not there on board.
It's not here. Next it is
So out here it's. so we can dispose of it.
It can be
Till
closed,
still. Yeah, we'll say till disposal of the appeal in this case.
continuing with the previous way.
Right. Heard, Mr.
Kiwi Ahmed.
AU Ahmed, learned counsel for the applicant. Who submits that the applicant has been convicted under section 379/34 IPC in connection with no, in Sessions case number 58/2013 passed by the Sessions Judge Golagat in Sessions case number 58/2013 and sentenced to undergo how much?
3 years. 3 years, man.
Here Ayub Khan, correct?
Yes, man.
3 years with a fine of rupees 20,000. In default, rigorous imprisonment for 3 months. Yes, sir. Where is the bail granted to you? Which page?
Should be in his application, not in the paper progress. Will be in his application.
No, in the judgment order, it's not there in the order. Or
Oh,
the learned trial court.
It is inbuilt in one of the sections of the CRPC, for 378.
No, but then it has
Ah.
to be recorded by the trial court
Yes,
somewhere.
it's to be.
Yes. So he will be asked to produce the set of public order by if it is there.
Let us see the record. LCR might be there. Because it is not here.
No, in the judgment, it's not. there.
It may be in the order sheet or something. It might be there.
Probably there is a separate order on the same.
Probably. The order, the LCR is not here.
LCR is.
Huh?
LCR is.
LCR is there. What is this? No, this is IA. No. Where is the LCR?
That's there, that's it.
LCR is here. It is here. In item 11, it is there. With LCR 7 files. It is with the registry or what? When you call that. We'll take it up after some time.
Not sure.
We'll take it up after some time. Let it be there. Yeah, Deborah had here only stated.
Your lordship, in this item number 9, your lordship, the name of the counsel for the appellant has not been reflected, your lordship.
Huh?
The name of the counsel for the appellant has not been reflected.
What is the name of the counsel for the appellant?
Actually, your lordship, T. Dury, lordship, we wanted to make sure that we have filed a WOCAR number, whether to WOCAR number is on record or not, we wanted to check, your lordship.
Just see item 9. Where were you when the case was called?
Your lordship, pardon, your lordship.
Just see Mr. T. Dury's Wakarat number is there on the back. Okay, what have we said in item 9? No, that's at the bottom, at the bottom. No one up here. No, then say, Mr. T. Dury appears on behalf of the appellant, Mr. Raju Nag, and submits that he has been recently engaged instead of the earlier councils. He submits that. He will file or you have filed?
Your lordship, we have filed, your lordship, it's probably on record, your
He submits that Wakalat Nama has also been filed by him. And submits that he will verify whether the same is on record or not. What about the IA?
I is,
You have submitted your W or not?
I have to check.
I release the
I-
matter after 2 weeks. You can. Give me that item 9, item 9, the IA.
I'll check. Yeah. I'll check for you. 355, it will be taxed. I think it's not there. It's not
No,
there.
it's not there.
Lordship, I'll file it within a week or so.
Okay, right. Mr. S. Jahan is granted a week's time to file written objection to the application under section 3. This is the matter after 2 weeks.
much obliged, your lordship.
My pleasure, Lordship. My lord, beg your apology, my lord. As for the last order, we could not take first steps upon the new date, on the new days of the sole respondent, my lord. I will take it during the course of the day.
Since this honorable court has already been decided on the same subject matter, dying declaration. It was made before the respondent, this mother, and ultimately this honorable court has set aside the conviction matter.
It depends on the facts and circumstances of each case. It
Yes, my
cannot,
lord. I have
you
gone
see.
through the decision of this honorable court, my lord, division bench, my lord.
maybe.
I have found, my lord, almost similar situation, my lord. And the
Oh,
dying declaration,
You see, almost is, there are many a slip between the cup and the lip.
now we'll,
Almost is neither here nor
yes.
there.
Now we'll come to the Azhar lordship, page 14 lordship.
Yes. Yes,
Lordship, have a look, my lord.
page 14 of what?
Page 14 of my read, this memo I have appeal, my lord.
Page 14.
Page 14. Annexure 1 lordship.
Yes,
For the lordship has found.
yes,
Yes. May I read, lordship?
yes.
With due respect, it is hereby inform you that that is 16, my lord,
Yes.
not 6, 16/9/2016 at about 10 o'clock at resident of Kherson.
6/9, not 16.
No, it should be, my lord,
Should be
typographical
16.
mistake, my lord. It should be 16, my lord. 16/9/2016 at 10 o'clock, at about 10 o'clock, a resident of Kherson village, namely Deepak Thapa, came to the residence of Krishna Bahadur of the same village. Krishna Bahadur is the deceased man. And who was sleeping at that moment, wake up and took him to nearby Hekiazan village for some reason. After some time, Sri Lila Chetri, a resident of Hekiazan village who was hiding himself on the way, assaulted said Krishna Bahadur, thereby caused grievous injury. Thereafter, calling 108 Krishna Thapa, was though admitted at Digboi IOC hospital, but later he succumbed during treatment. It is therefore humbly prayed that your honor would take appropriate action. Now, case has been registered accordingly. Now, lordship will find the PW1, my lord, that charge sheet, my lord, page 19, lordship. The column 8, Lordship, it will be very important, my lord. Page 20, Lordship. Deepak Thapa has been exonerated from the charge, my lord. Lordship will find at page 20, may I read, Lordship?
Yes,
Charge of information, nature of offense and circumstances connected with if so concise, detailed and under what section of the penal code charge. Brief fact of the charge sheet is that on 17/9/2016 in the morning at about 20:20, the informant Sri Milan Thapa, son of late Pratap Thapa, resident of Kherdan, Nepali Gaon under Digboi police station in the district of Tinsukia, had lodged a written FIR and informed inter alia therein that in the previous night at 10 p.m., one Deepak Thapa, a resident of Kherjan village, came to the residence of co-villager Krishna Bahadur, who was sleeping at that moment, and awoke him and accompanied him to nearby Dhekiajan village. After a short while, Sri Leela Chetri, a resident of Dhekiajan village, who was hiding himself on the way, assaulted Krishna Bahadur and thereby caused grievous hurt. Thereafter, with the help of 108 service, Krishna Bahadur Thapa was admitted at IOC Hospital, Digboi. However, during treatment, Krishna Bahadur was expired. Accordingly, case was registered and investigated. Now, during the time of investigation, place of occurrence was visited, statement of witnesses were taken, inquest report of the body was performed, and the body was sent for postmortem, and the postmortem report was collected. FIR named accused Sri Leela Chetri has been arrested during investigation and sent to Hajur. However, no such substantial evidence has been found against other named accused Sri Deepak Thapa, and hence he could not be entangled with this case. It is therefore prayed that Honorable Court may exonerate him from the charge. During investigation, sufficient material has been found against the arrested accused Leela Chetri, son of so-and-so, Jit Bahadur Chetri, under section 302 IPC instead of section 302-34 IPC. Level against at the time of filing of the FIR. And accordingly, this charge sheet has been submitted accordingly, enclosing therewith a copy of the postmortem report, a seizure list, and a case map of the place of occurrence. Now, my lord, this Deepak Thapa is nowhere in the picture. Had there been the Deepak Thapa as a last seen witness, then matter is different. It had been corroborated the fact. It has not been done. Now, Lordship will find the deposition of PW1 at page 24.
yes,
Lordship. This is translated version, my lord, I am reading. As it about 40 years taken in oath or solemn affirmation under provisions of the Indian oath, this is 27/11/18. My name is Sri Milan Thapa. He is the informant, my lord. Milan Thapa. My father's name is Let Pratap Singh Thapa. Police station Digboi. I reside at present Kherjan, Nepali Gaon. I am a cultivator. On oath, I am the informant of this case. I know the accused Leela Chetri. This is Krishna Bahadur Thapa, is my nephew. Is the relative. The incident.
so I know accused Leela Chetri. Okay.
Yes. Nephew. The incident occurred almost 2 years back. Incident occurred at about 9 p.m. Earlier in the FIR, he said 10 p.m. On 19/9/2016. Here he has said 8 and 9, but in FIR he said 10 p.m.
Those are small,
Yes,
trivial.
my lord, I'm just coming, my lord.
Do you remember what time you ate your dinner 20 days back?
Yes.
The time you remember, you won't remember.
Since FIR
Could be
was
7:30, it could be 8:30, it could be 6:45
now,
also.
I am on
So
that.
what is this 1-2 hours?
I am not on that, my lord.
Yes.
At that time, I was at my residence. Residence of Krishna Bahadur Chetri is about 100 to 150 meters away from my residence. At that moment, while I was at my home, heard hulla, hue and cry that Krishna was assaulted by Leela Chetri. He heard it. Then I ran from home And so at about half kilometer from my residence, Krishna was lying on the road in injured condition. On being asked, Krishna informed that Leela has assaulted him and became speechless. This is the fact he has stated before the now Lordship will see. That is why for understanding my lord, that this bold has been made to understand my lord. At that moment, by the side of Krishna, there were Dhan Bahadur Thapa, Dil Bahadur Thapa, Lok Bahadur Thapa, and many other persons were present with me. But they are not the PWs, my lord. We shipped Krishna to IOC hospital with the help of 108. Doctor informed that Krishna was died. Thereafter said that he had not gone to hospital. Dil Bahadur Thapa brought to hospital. I went to police station in the night itself. There I was asked to come in the next morning, but Azhar was lost on the date of incident. Exhibit 1 is the Azhar lost by me. And exhibit 1 is my signature thereon. Police has performed the postmortem report of the dead body. I accompanied with the dead body to Tinsukia. Exhibit 2 is the inquest report, and so and so is my signature. Cross name of the writer is not there in the Azhar. It was read over to me. I have not stated before the police about the injuries inflicted by the accused. On being asked by the police, I have not disclosed anything. This is the discrepancy. I have not disclosed anything where from I received the information. I have not seen that the accused had assaulted Krishna. It is not a fact that I have not deposed before the police that Krishna had uttered the name of Leela. It is not a fact that I have not disclosed before the police about the house of the accused and the spot where Krishna was lying in injured condition. It is not a fact that I had not deposed regarding the presence of Dhan Bahadur, Dil Bahadur, and Lok Bahadur. It is not fact that Krishna, being my relative, I have given false evidence. Now Lordship will find. In similarly, his brother is also present.
Whose brother?
This Milan, the informant brother. He is in PW 4. Now I'm coming to that, Malat. Page 29, Malat, PW 2. PW 2. My name is Dil Bahadur Thapa, Milan Thapa, Dil Bahadur Thapa, and my father's name is Sri Dhan Bahadur Thapa. Dhan Bahadur Thapa. The cousin brother. My father's name is Dhan Bahadur Thapa, police station Digboy Central. On oath, I know the informant Milan Thapa, accused Leela Chetri, and the deceased Krishna Bahadur Thapa. Krishna Bahadur Thapa is the son of my paternal uncle. Date of the incident was 16, and the year was 2016. I forgot the month. Incident was occurred at night hours, about 9:10 p.m. At the time of incident, I was busy with the study at home. Then my friend Vishal Pradhan rang and informed that Krishna Bahadur Thapa was assaulted and was lying on the road. I had gone to the place of occurrence, which was about 1 kilometer away from my residence. I have seen that Krishna was lying in injured condition. There was injury on his head, blood oozing from his mouth and nose. At that relevant point of time, Krishna was though alive, but was speechless. He could not speak anything, madam. When I reached there, I found my brother Himalaya Thapa there by the side of Krishna. Thereafter, the villager came there. This is very relevant. At that time, nobody was there. He was found only the Himalaya Thapa at that time. Yes, Himalaya was not the witness, but he was there, and he said that he was at that time Krishna was this deceased person was speechless. He could not speak. When I found my brother Himalaya Thapa there by the side of the Krishna. Krishna was the deceased. Thereafter, the villagers came there. We shifted Krishna to IOC hospital with the help of 108. Krishna died there. On the night of the incident itself, we lodged FIR at the police station. In the next morning, police recovered the bamboo stick from the house of the accused, used in assaulting Krishna. Accused used the bamboo stick to kill Krishna. This distance between the place where Krishna was lying and the residence of the accused is almost 100 meters or so. Cross, I could not remember whether I had informed before police that Vishal Pradhan had informed me about the incident. It is not a fact that I have stated before police that Rudra Chetri had informed me about the incident. It is not a fact that I have not stated before the police that I had seen Krishna Thapa in injured condition. I could not remember the phone number of Vishal Pradhan. I have not seen who assaulted Krishna Thapa. It is not a fact that as Krishna is my relative, so I have deposed falsely. It is not a fact that I have deposed falsely that the bamboo stick has been recovered from the house of the accused. Now, Lordship will find the accused number, the PW3. Is also relative matter. 1, 2, 3. Annexure 3 matter. Page 34 minor. PW3 matter. My name is Lok Bahadur Thapa. My father's name is Kumar Thapa. So and so, Digboi police station, so and so. On oath, I know the informant Milan Thapa. Accused Leela Chetri and this is Krishna Bahadur Thapa. Krishna is son of my maternal uncle. Some was paternal uncle, some was maternal uncle. Incident was occurred almost 1.5 or 2 years back. It was occurred at about 9 o'clock at night. At the time of incident, while I was at my residence, Dil Bahadur Thapa came and informed me that Krishna was killed by Leela Chetri after an altercation. Then I went with Dil Bahadur to the place where Krishna was lying. The place was about half kilometer away from my residence where Krishna was lying in injured condition. He was speechless, madam. Here he has also said he was speechless. Since it was dark due to night, so we had not seen where he sustained injury. Thereafter, Dil Bahadur managed 108 to shift Krishna to IOC hospital. Thereafter, Dil Bahadur rang me from hospital that Krishna was died. Then I reached hospital by bike. On the night itself, Uncle Milan Thapa lost the FIR. As per my knowledge, Krishna was subjected to physical assault and dragged from house and kept on the road. Though police went to the residence of the accused, searching him, but he was not there, but eloped therefrom. Later on came to know that in the next day, police was successfully in recovering the bamboo stick from the house of the accused. Now, all the time they are saying the stick is recovered from the house of the accused. Police says that it is recovered from the house of the place of occurrence. The said bamboo was brought to the police station and there I have signed on the seizure list. Exhibit 3 is the seizure list and Exhibit 3.1 is my signature there also. Now, cross Malay, it is not a fact that I have not stated before the police station, police that Dil Bahadur had not informed me about the incident. I have not stated before the police that Krishna was assaulted at his residence by Leela. And thereafter, leave him at the road. He has not stated. I have put my signature on the seizure list so and so at the police station. I have not seen the place where from police have recovered the bamboo. I have not personally seen the assault of Krishna. It is not a fact that I have deposed falsely because Krishna being my relative. Now, 4. PW4 matter. PW4 is also saying, Malat, he is the Anil Thapa. My father's name is Let Pratap Thapa, police station Digboi. I reside so and so. On oath, informant. Milan Thapa is my own brother. The informant is his own brother. I know the accused Leela
So
Chetri.
what do you want to say basically? What do
Ah.
you want to say?
My lord, here,
You cannot go with.
my lord, here, the whole judgment, my lord, and the conviction has been made on the sole basis of the dying declaration made before the PW1. And the PW1, though he came in later stage, the PW2 says that at the time when he came to the police, place of occurrence, my lord, the Krishna was lying, and his brother was standing nearby the dead body. There was nobody else. Then he says that at that time he was speechless. He could not speak. And accordingly, they took the person to the hospital, IOC hospital, my lord. And meaning thereby, my lord, if that being the position, my lord, how the PW1 say that at the time of death, he told me that Leela Chetri assaulted me. This totally exaggerate evidence of the PW1. And dying declaration, my lord, that must be trustworthy, reliability, and it must be either before the doctor or before the magistrate. It has not been done. And
Right.
otherwise, if not, my lord, the oral evidence, oral dying declaration can be made, but it must be trustworthy.
That is only in case it is.
Only, yeah, only this case, my lord. Only on that basis, my lord, some of the judgment has been relied. And I have seen, my lord, the latest judgment of the Supreme Court has also said in 2022 that when my lord, I'm just reading out, my lord, that has been already stated herein itself, in the judgment itself, my lord. In the judgment itself, my lord. It's very. It's a judgment of 2022, my lord. No, it is 22. That is, my lord, just para 29, my lord, of the judgment, page 96, my lord. It has been said, in the case of Kamal Khudal versus the state of Assam on 14 July 2022, it was held by Supreme Court that in para 21, the law regarding the nature, scope, and value as a piece of evidence of oral and written dying declaration is now fairly well settled by various judicial decisions of this court. A dying declaration, oral or written, before it could be relied upon, must pass a test of reliability, as it is a statement made in the absence of the accused, and there is no opportunity to the accused even to put it through the fire of cross-examination to test its genuinity or veracity. The court has therefore to subject it to close scrutiny. But once the court is satisfied that it is a truthful version as to the circumstances in which they have resulted and the person causing injury, the law doesn't expect that there should be corroborated before it can be relied on. However, if there are infirmities and the court does not find it safe to base any conclusion on it without some further evidence to support it, the question of corroboration arises. There is no corroboration, neither in the.
That depends, that will arise only if the court does not, if it does not inspire the confidence of the court, that's all.
No, since
It does not say that,
yes,
it
No.
does not say that
No,
all confessional statements have to be corroborated. It says that, in fact, if it inspires the confidence, then corroboration is not required.
some of the judgment I have found, my lord, even in the
Mr.
latest.
Counsel, there be
latest-
judgment this
no.
side, that side.
No, no, even in the latest judgment of the Honorable Court, it has been said that that trustworthy, when there is the lacking of trustworthy or it is not reliable, corroboration must be there. And to corroborate the fact, my lord, when there is a discrepancy when he made the statement before the police, that has to be corroborated. Or my lord, when there here, my lord, when I'm questioning the trustworthy of PW1, PW2, PW3, PW4. PW2 came before the Milan Thapa, before the informant. Before the PW1, PW2 came before the came in the spot, my lord. He says that at that time when he reached, he was speechless. And if a person is speechless, how we can give this dying declaration before PW1 after some time, my lord? And where 2, 3, 4 others did not say anything. And all the PWs are saying that he was speechless at the time. How can it be trustworthy of PW1's statement, my lord? This dying declaration, it was. And Deepak Thapa, the last person who was accompanied with the deceased, he has not been the prosecution witness. Had he been, then he could link up the chain would have come up. There was no chain.
PW2 does not say that he was the first to come. Did he say that?
Yes, my lord, lordship will say, lordship will find. Yeah, no, what he said, we have to understand.
Father was I found my brother.
It's very,
I found my brother. That's all he says. He does not say that there
No,
were no other person.
no, my lord, here, what I want to praise before lordship is that
Anyway,
there was injury on his head.
okay, we have basically heard what you're trying to say. Basically, you're basically saying that Deepak Thapa was who was last seen
Yes.
with that person, with the deceased, should have been made a prosecution witness. And the the conviction having been made only on the basis of the statement made by PW1, to the effect that a confessional statement had been made, which had not been stated in his 161 statement. The evidence of PW1 juxtaposed with the evidence of PW2 does not prove the guilt of the. That's all. That's it. That's
Yes,
it.
yes, and PW2 already that again this. I'm sorry, my lord, just irritating your lordship, my lord. PW2, my lord, just I'm reading one second, my lord.
Yes.
There was no only when he came, my lord. Page 29, my lord. I am again reading, my lord. I know the Krishna Madhav Thapa, so and so, that 16 and the year 2000. I forgot the month. Incident was occurred at night, so and so. At the time of incident, I was busy with the study at home. Then my friend Vishal Pradhan rang and informed that Krishna Bahadur Thapa was assaulted and was lying in the so and so. I had gone to the place of occurrence. Now, lordship will find. I had gone to the place of occurrence, which was about 1 kilometer away from my residence. I have seen that Krishna was lying injured condition. There was injury on his head, blood oozing from his mouth. Blood was coming out, bleeding it was. At that relevant point of time, Krishna was though alive, but was speechless. When I reached there, I found my brother Himalaya Thapa. And Himalaya is not a PW. Himalaya Thapa and others were not there, my lord. PW1 is also not there as per the deposition of PW2, my lord. And how he can say these things, my lord? He is exaggerating and it's an afterthought, my lord. The Himalaya Thapa, he has been he was present at that time. He has not been met by prosecution witness. When he has specifically said, Himalaya Thapa was the only person at the time of incident. And he did not say that PW1 is there. Subsequently came PW1.
That's all.
That's my point, my lord.
Okay. Let's see the other statement.
Lordship, what,
But there is one aspect,
Lordship.
you have forgotten. PW3 has stated that, PW3 has stated that Dil Bahadur Thapa had told him that, this, appellant had killed, had assaulted the deceased. Now, when you look at PW1's evidence, he says that the, Dan Bahadur Thapa, Dil Bahadur Thapa and Lok Bahadur Thapa were also there at the time with him. Now, though they were not made witnesses, but
On-
PW3 has corroborated the evidence given by PW1 with regard to the presence of the appellant.
Dil Bahadur, PW3, my lord,
You come to page
PW
34.
yes.
You come to
PW
page
yes, I'm
34.
reading, my lord.
Hmm.
Just after that bold portion, he said thereafter Dil Bahadur managed 108 to shift so.
Yes,
Thereafter Dil Bahadur rang me from hospital so. Before that,
yes,
somewhere.
At
Then
the
I went
moment.
with Dil Bahadur to the place was so. Before that,
Yes,
Dil
at-
Bahadur came and informed me that Krishna was killed by Leela Chetty.
no. Came inform, my lord, that is not the direct evidence, my lord. It is not the eyewitness. They are not the eyewitness. They are just somebody rang up and told that we have
Okay,
heard the hulla. There
okay.
was no eyewitness, my lord.
Yes.
In fact, what I can see is this incident had taken place at night, 8 and 9 PM in the month of September. Now, what somebody, everyone had come to know after the incident had taken place and they had rushed to the place of occurrence. Now, Lordship had seen so many judgments, it is not possible for someone to say who were present at that point of time.
What is that judgment?
That Shahaja is there. I have referred. It's difficult for anyone to say who was there, who was not there. They will all point towards the victim and they have gone to the victim. What has happened, they will see. So perhaps they have not seen who was there. And as far as the oral tying declaration is concerned, what I find is prudence requires that there has to be some corroboration. Oral tying declaration, not written by magistrate and all. Here there is an oral tying declaration and he perhaps reached first and he was told and he said after telling he became speechless. And the people, the rest of the witnesses, they have reached little late. They found when he was already speechless. So oral tying declaration is not unbelievable. Plus, there are few contradictions. The trial court had not convicted only on oral tying declaration. They have gone to other evidences, other circumstantial evidence, like the bamboo was seized from the wife of the applicant. There was an altercation between the applicant and the deceased. The conduct of the applicant, of course, he was not found, he was absconding. So these circumstances, the homicidal death on head, the bamboo, which can cause the particular
What about
injury.
this Deepak Thapa? who
Deepak
had-
Thapa, of course, he should have been examined. Even charge sheet, I don't find his name as a witness. Deepak Thapa is not there. Of course, there are so many flaws in investigation, I don't deny it. These people should have been examined. But the fact remains, there was an oral tying declaration. And the corroboration is that there was quarrel amongst them. Witnesses have stated. Then the bamboo was recovered from the house of the accused, handed over by the wife.
House of the accused, the other PW says, police says, you see
At
the
the place of
investigation officer,
occurrence.
place of occurrence.
Yes, anybody else?
And
Police shape place of occurrence.
yes,
Yes.
police said at the place of occurrence, but then the other witnesses have said from the wife. And the homicidal witness.
There is so many contradiction and discrepancies.
Contradiction as far as oral tying declaration, there is no contradiction.
There are
In far as, as far as. the
Anybody else
PW
is there? No one. Your
Lord-
first?
Yes, he is for the informant.
Yes, anything to say?
As he speaks that there is a contradiction in tying declaration. But during cross-examination, even he has not put a suggestion that the before the death of the disease, he has not said the name of, he has not uttered the name of Leela. There
He
is
has
no Leela, who is the applicant.
No, a suggestion was given to him
No.
and he denied the suggestion that he had
It
not
is-
stated.
Uh, it is only the suggestion
Okay, in
that
the was the 161 statement, does it talk about any oral?
And that,
Right,
of
uh,
course, I have to see, otherwise.
Can we see the,
something we said-
yes, Rakesh, the records? Just show it to the.
I'll see.
CP.
But we'll go to the police statement then.
No,
if
no,
there
yes,
is-
the 161 statement,
Huh.
in any event, the 161 statement that has not been put,
Yes, I mean,
he has not been confronted with that aspect.
as far as police's statement said, the contradiction only to the extent is Milan Thapa did not state before me from whom he got the information about the incident. He had not disclosed before me at the place of occurrence. He met Dhan Bahadur Thapa and
So
Lokha.
you have not contradicted the
There is no
evidence of
contradiction.
of PW1, that is the problem. To contradict, you have to put that portion of the statement to the witness and also to the IO. In persons to, I think, VK Mishra's case.
Now we can Mishra's case. I'll see the statement of the.
In one judgment, my lord, 2019.
Finally. To file GR.
Anyway, even supposing he did not make in 161,
But even that.
he has not been confronted in
Ah,
terms of VK Mishra's case.
Yes,
That
did
is the
not been contradicted. We need not look into the 161 actually.
Not required. I
the applicant even not contradicted that bamboo stick was not used.
Anyway, right.
Since Lordship is aware, but when the two views are possible, my lord, two views are possible on the case of record on pointing to the guilt of the accused and the other his innocence. My lord, indeed entitled to have the benefit of one each which is favorable to him. All the judiciary,
That we will decide at the time of appeal, hearing the final. appeal.
no, since
Not at the time of bail.
no, now,
Or,
my lord,
right.
since in the family, my lord, only two kids are there, small kids, my lord. Only he has been falsely implicated in the case, my lord. Now they are in the footpath, my lord. Because the
But
main
to-
person now under the jail custody, my lord.
And
Without having any-
what about the family of the deceased? Where are they? In a golden house or something?
No, since the person would have been assaulted, then matter is different, my lord. I admit. I would have been, my lord, in the custody, that's all right, my lord.
Prima facie, you see, the
But-
trial court has found you guilty. So
No.
we'll have to see that,
No,
and if
prima facie-
you
My
can
lord.
have showed.
My lord, only my prayer before lordship. The prima facie lordship has already gone through it. There is so many discrepancies that has not been examined by the full law, my lord.
We will meticulously go into that at the time of hearing the appeal, but not at this
So
stage.
that will, my lord, that will be, my lord, too much delay, my lord, because ultimately his whole life will go, my lord. If lordship will find that he is innocent and acquitted from the acquittal,
If,
then whole life will be in the jail custody and subsequently he will say that, oh, I have been acquitted, but nothing has been remained in life.
he had.
The
he-
whole
he-
family, the person has gone, that's different. My
Okay,
lord.
right.
The existing family members already be in doom, my lord.
Heard Mr. Beach Hetty,
So lordship will consider that aspect.
learned counsel for the applicant. Also heard Ms. S. Jahan, additional PP, and Mr. B. Fukan for the respondent number 2. Fukan, Hussain. This application has been filed under section 389(3) CRPC for suspension of the sentence passed by the Court of the Learned Additional Sessions Judge, bracket FTC -1, bracket close, Margarita. In sessions case number 24, bracket M/2017, arising out of Dig Boy PS case number 154/2016, by which the applicant has been convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for life, with a fine of rupees 5,000, in default, rigorous imprisonment for 6 months. The applicant's counsel submits that the conviction of the applicant / appellant has been done by the learned trial court only on the basis of the evidence of PW1, who had stated that the deceased, prior to his death, had laid the blame for the assault on the deceased onto the applicant. He submits that while PW1 had stated that had stated in his evidence that Dan Bahadur Thapa, DHA, Dil Bahadur Thapa, and Lok Bahadur Thapa, and many others were present at the time the deceased informed him that the applicant had assaulted him, the above 3 persons were not made prosecution witnesses. Further, Deepak Thapa, who had apparently taken out the deceased from his house at around 10 PM on 19/9/2016, has also not been made a prosecution witness despite being last seen with the deceased. He also submits that there is a discrepancy with regard to the place of recovery of the bamboo which had been used to assault the deceased. In view of the evidence of PW2 also shows that PW2 was the witness who was first present by the side of the deceased after his assault, along with one
Himalaya.
Himalaya, HIMALAY, Himalaya Thapa. At that particular time, the deceased was speechless. As such, no confessional statement, no dying declaration could have been made by the deceased. He also submits that an oral dying declaration would have to be subjected to close scrutiny, and as there is nothing to show that PW1 was present at the place of occurrence, corroboration of the dying declaration was required prior to convicting the applicant. Accordingly, as no corroboration is there, the dying declaration could not have been the basis for convicting the appellant. Consequently, the sentence imposed upon the applicant should be suspended and the applicant should be released on it. Next para. The additional PP and Mr. B, B for Bombay,
Bombay.
B Fugan. Learned counsel for the respondent number 2. Submit that. No, before that, he also read. The applicant's counsel also submits that the evidence of PW1 to the effect that an oral dying declaration had been made by the deceased to him has not been stated by PW1 during his statement made under section 161 CRPC. Next paragraph. Ms. Swenso and Bishop PP and Swenso, counsel for the respondent number 2, submit that the evidence of PW1 cannot be discarded on the alleged ground that on the alleged ground that PW1 had not made any statement under section 161 CRPC to the effect that the deceased had not given any dying declaration. Full stop. This is due to the fact that PW1 was not confronted with any such with the said portion of his statement made under section 161, and neither was the IO examined on that score, as required by the as held by the apex court in the case of VK Mishra versus State of Uttarakhand, 2015
9 SCC,
9 SCC.
they had page number, I'll just give them.
Okay, whatever, that
This
number.
is, I've got it.
Okay.
This is 2019, no,
15,
2015,
nine.
9 SCC. Oh, yeah, 2015. 9 SCC 588.
588. The they also submit that that there is nothing to show that PW2 was the first to arrive at the scene of the crime with Himalaya Thapa, as the evidence of witnesses can differ as held by various judgments of the Supreme Court. That's all. Anything else? They accordingly submit that the application should be rejected. Full stop. We have heard the learned counsel for the parties. Full stop. On perusing the evidence adduced by the parties, we find that we find that PW1 has not been confronted with any question during his first examination to the effect that statement before the police that dying declaration had not been made by the deceased to him. Full stop. The IO also was not confronted on this call.
Actually, he was confronted and he said that he had.
Yes, confronted.
Lordship, it's
Where's
one
the
line.
confrontation? I didn't find the confrontation.
One line, it is not a fact at page number 25.
Yeah.
It is not a fact. I have not deposed before the police that Krishna had uttered the name of Leela. So this will be dying
Uttered the
declaration.
name, okay, uttered the name Leela. Okay. What have I said? No, before that. Uttered the name of Leela, but in what context?
Yes, this is not there.
What have I said?
But this is the only statement
Huh?
made. It's okay.
Full stop. However, the PW1 in his cross-examination had deposed that, no, had denied the suggestion that the deceased had not uttered the name of the applicant to PW1. Next. PW3 in his evidence had also stated that Dil Bahadur Thapa has told him that the deceased had been assaulted by the applicant. Without going minutely into the details of the evidence before us, we are of the view that the sentence imposed upon the applicant cannot be suspended and the applicant released on bail at this stage. So the application is accordingly rejected. Then in the main case, you're right. As LCR has arrived, registry to prepare the paper book. This is the matter after 4 weeks.
In fact, the case diary is not here with the LCR. This little
And you look into that,
lordship cases.
Miss
But no, this is actually in the Nellore court, so we don't have any
Control.
control. Of course, there will be a copy in the police station or in the SP's
see.
office, but we'll see during the hearing.
Can it be the early hearing
Then the paper book be made.
after completing of the lordship? May
So
observe.
that's why we have said 4 weeks.
Ah.
Once 4 weeks is there, you see, the orders usually passed are list the matter after preparation of paper book. Out here, we have said 4 weeks, so that even if they don't complete, it will be here. So just one thing you write, in the PP statement, it has been submitted by the learned PP that the CD is not a part of the LCR. That, no, just say that, submit that she cannot find the, no, just say us actually, forget the PP. Just say that,
Subject to correction, of course, lordship, lordship Thakuria can see once, but I've not got.
you said that,
Yes, yes. I've seen that there are 3 files, A, B, there can be some other LCR, no.
yes,
But I don't find.
I'm helping her today, madam. Since she supplied the objection copy to me, and that has been taken away again from me, madam. And objecting against me, madam.
Oh, see, that
She doesn't have the copy of the objection
need
herself.
not be said that.
Yeah. Copy to them.
okay, yes, I don't say, PP just say that. We find that, we find that, we do not find a copy of the CD in the LCR. Just put that, huh? Then we can.
Anyway, sir, my lord, I'm sorry, my lord. I expected. I expected.
Item number 15 and 16. Yes,
3,000 yes paid today, madam.
how much has he paid today?
3,000.
3,000.
Yes, ma'am.
And you're supposed to
Of-
pay
of
how
this
much?
month.
30,000. August, you're supposed to pay 15.
Yes, ma'am.
And
This month,
September,
this month 15. 30,000.
August, you were supposed to pay 15. Yeah, and you paid 3,000.
मेरा वाइफ से बात किया था, बोला था कि मैं नहीं सकती हूँ, मेरा मम्मी तबीयत बहुत खराब है, एक प्रॉब्लम है, पिताजी भी है।
All
बात किया तो बोला ठीक है देखता हूँ, ऐसा बोला है। तो वो हम बोला नहीं सक रहा है, लोन लेके भी दे दिया, लोन लेके था, अभी नहीं सक रहा हूँ, बोल क्या बोला क्या करे, बोलिए आप ऐसा
where is the council for the other side?
पैर ठोकरा, बोल के
You,
बोला,
let us wait, let us wait for you. I'll wait for you.
Coming to records. Bail, bail. No,
But the records are there.
and they found they have,
They found it. Thank God we went,
no,
they went looking for it. Now let us see the record. And let us see if,
In item number 13, I have been told by my friend that he has already annexed that order, Lordship. That criminal appeal 184
hey, where have you annexed? In the appeal?
in the IA.
In the IA?
IA.
but
Give me the
I,
IA 393.
Court IA number 438, Lordship.
that is disposed of,
Page number 59, bail order is there.
438, isn't it?
Yes.
that is the
438.
disposed of, I.
Bail has been granted without suspending sentence.
No, bail will be granted by the lower court only till filing of the appeal before the high court. This is what 389 says. But after it is filed in the high court, it is prerogative of your lordships to pass again bail orders. Or continuing with the previous bail, as they say.
Can a bail be granted without suspending the sentence?
No, cannot be granted because the only provision is 389 by the high court. Lordship will see 389 too, where it is granted by the.
Just a minute.
Lordship can see.
Ah, it will soon.
Lordship can see 389(3). Till what period the lower court will grant bail? When the sentence is not more than 3 years. 389(3). You'll also get. Where the convicted person satisfies the court by which he is convicted that he intends to present an appeal, the court shall, where such person being on bail, is sentenced to imprisonment.
No period is given.
The requirement is that now she will see 389, yes. Where such person being on bail is sentenced to imprisonment for a term not exceeding 3 years, or Lordship will skip this. Order that the convicted person be released on bail unless there are special reasons for refusing bail for such period as will afford sufficient time to present the appeal and obtain orders from the appellate court. Under subsection 1, and the sentence of imprisonment shall, so long as he is so released on bail, be deemed to be suspended. So after it is filed, then they have to take or obtain orders from the appellate court under subsection 1.
No, you're reading 389, correct?
389 subclause.
Suspension of
sub-
sentence pending the appeal.
The Lordship will go to subsection 3. Where the convicted person satisfies the court. Lordship got it?
Yes.
By which he is convicted that he intends to present an appeal, the court shall, where such person being on bail is sentenced to imprisonment for a term not exceeding 3 years, or lordship can skip. Thereafter, lordship will see the court shall order, that means the lower court, that the convicted person be released on bail unless there are special reasons for refusing bail for such period as will afford sufficient time to present the appeal and obtain orders from the appellate court under subsection 1. So till that period, then they'll have to obtain orders under 389(1), again suspension of sentence and bail. So he can be granted bail only till filing of the appeal. That perhaps is
The
done.
problem is that out here, there's no date, no time limit given.
Acha.
Leaving that aside. Fixing for submission of copy of the order. Okay, till 24/7. But then this is after, but after 24/7, there is no order. It cannot be done. We have to say that deemed this is deemed suspension. Yes, because we have to keep 10 years. So, but now it is deemed suspension. This order will be illegal also.
Lordship found out something.
Huh?
Lordship found out something. And
Eh, Basically, the time limit for giving a stay to the trial court, it did not say that for 2 weeks or 1 week. It says that they fixed 24/7,
acha.
22 for submission of stay order of the High Court,
Okay.
the trial court. So basically, bail granted till 24/7.
Acha.
It can be inferred.
Hmm.
Now the bail is given on 17/8. Beyond the time limit.
Oh,
Because July it was supposed to be given.
Mhm.
August 17 it was given, the bail by this court,
by the Honorable High Court
by the single bench.
or by the single bench? Oh,
Unfortunately, there is no suspension of the sentence.
Oh,
Now, so basically, it can be inferred that there was a deemed suspension of the sentence. Otherwise, the order will not be.
yes,
Proper.
operative.
So we'll have to clarify that, I think.
Ah, yes.
And so basically,
And the application was not closed. It was kept alive
no, disposed of.
or disposed of.
Disposed of. It's subject to compliance of above, this application stands disposed.
Acha, the application which is not there in the list. It's with-
Not there in the list.
Acha, it's with Rafiqul.
Subject to compliance in a sense, you were allowed to, I mean, press bail was granted. Have you punished your bail bond again before the trial, before the learning session judge?
That we have.
After 17.
No, this is for Rafiqul
Rafiqul
Islam.
only.
Yes, for.
Ayub, it's not there.
What about for Ayub? Where is your bail?
It's not any smell.
Not annex.
No, you did not search in the same order.
Order is same order, Manata. I may be. 438, Manata.
Oh, perhaps
Four
he-
38. Let me see.
I.
438 is only for Rafiqul Islam.
So that order.
Order worship, I name is there. Page 59, Lordship. Can you tell us 27 order?
Page 59.
Yes, Lordship.
Perhaps and another is
No,
there.
page 59 is an order passed by the trial court.
Yes, Lordship, their lordship.
Now, so this trial court order is up till 24/7. Where is the high court order for your case?
Malas, I got order in the, in criminal appeal 164, madam, the order dated 4/11 to
Give me
2023.
164.
164 is the appeal.
164 is the appeal
He's saying
filed
that-
by,
that- that bail order is
Ayub
passed in the
Khan.
main appeal itself.
Huh?
He's saying main.
That's a-
bail
let
order
us
is
see.
passed in the
Let
main
us
appeal itself.
Many? Big
164. Which page, which page?
In main appeal, it will be also criminal appeal number 164.
164, madam.
We have got 164. Which page in 164? There are so many pages.
It is court's order.
Court's
The
order.
order sheet, order sheet.
Oh, in the order sheet.
4/11 2023 order.
411, 23.
Hmm,
411, 22.
23.
411, 23.
20
No, no, no.
22, my lord.
22.
411, 23. Hmm.
Ah,
See? I didn't have. What is there in the order? I did not check.
It says, it just says the appellant is allowed to remain on previous bail till disposal of the appeal.
Oh, and this is not in consonance with the provision, but again, the lordship has to deem everything. And nothing is passed in the IA, perhaps.
We'll have to clarify the IIT. That 393 is here. Okay, today.
All hot stuff.
He might get the benefit
Yes.
of this hodgepodge.
Hodgepodge orders.
Yes.
Mr. Azad
mean,
will get the benefit.
Like this confusing order, not hodgepodge, confusing. Anyway, but the suspension of sentence is different thing and bail is different,
Different.
but it has to be deemed to be suspension. Otherwise. Okay, we'll take up the thing first, 393 first, huh? We'll give it 393. But since 393 also been given. Again, he has given an order 1/8 principle. Okay, right. Heard, Mr.
KU Ahmed.
K.U. Ahmed, learned counsel for the applicant / appellant Ayub Khan.
Yes.
Full stop. Miss S. Jahan appears for the state. This application has been filed under section 389 CRPC for suspending the sentence passed by the learned Sessions Judge Golaghat pertaining to the judgment dated 18/6/22 in Sessions Case number 58/23, by which the applicant Ayub Khan has been convicted under section 379/34 IPC, along with co-accused Rafiqul Islam. Who is also convicted and sentenced on the same charge. Full stop. Besides the above two persons, the co-accused co-accused Ibrahim Ali was convicted under section 302,
302 and 201.
302 and 201 IPC,
Rated 34.
both 34. 302/34
Yes.
and 201/34 IPC. Write the same judgment. System. Next para. The applicant Ayub Khan and Rafiqul Islam were sentenced to undergo 3 years rigorous imprisonment with a fine of rupees 20,000 each. In default, rigorous imprisonment for 3 months under section 379/34 IPC. The learned trial court thereafter, the learned trial court thereafter where is the order of the learned trial court granting you bail?
Page 59, Lordship, IA 180, IA 438.
IA 430.
Yes, sir.
The learned trial court thereafter passed an order dated 27/6/2022 in the disposed of sessions case number 58 of 2013, wherein it granted bail to the applicant Ayub Khan and Rafiqul Islam and fixed 24/7/2022 for submission of the stay order of this court in respect of the judgment dated 18/6/22 passed by the learned trial. Oh, no, sorry. Date of sentencing again different out here. In respect of the date of the sentence order dated 24/6/2022. Yes, sir. Next para. The applicant Ayub Khan filed criminal appeal 164/22 challenging his conviction and also filed an application and also filed IA criminal 393/22 praying for suspension of the sentence and grant of bail under section 389 CRPC. First one. The single bench of this court wide order dated 1/8/22 passed in IA criminal 393/22 gave interim bail to the applicant Ayub Khan till 5/9/22. And by order dated 4/11/22. And 5/1/23. Comma, the interim bail was extended by the learned single judge. Though there is no, wait, and by order dated 4/11/22 and 5/1/23 passed in. No, not passed it. No, that's correct. No change, no change. Full stop. Though the learned single judge has not specifically has not specifically suspended the sentence dated. This also is wrong, no? 24/6/22 passed by the learned trial court. Comma. An inference. No, can be made that the learned single judge has suspended the sentence passed against the applicant Ayub Khan in sessions case number in the judgment dated 18/6/22 and sessions case number 58/2023. Passed in sessions case number 58/2023. In terms of section 389(1) CRPC. Full stop. The applicant Ayub Khan, having been on bail in view of the order of bail given by the learned trial court and by the single judge, by the learned single judge of this court since July 2022. Comma. There is nothing to be decided in the present application because it has said that bail will be till final disposal of the appeal.
Yes.
What have we said? Full stop. As the applicant has been granted bail by the learned single judge till final disposal of the appeal as per the order dated 4/11/2022 passed in criminal appeal 164/2020. The have you given a bond and all the bail order? No bond? You have given?
Chairman.
Huh?
Yes, ma'am.
You have given before the learned trial court?
Yes, ma'am.
They have to, otherwise they'll
They have
not be
given,
allowed.
yeah. I'm not sure. The application is accordingly disposed of.
I is disposed of.
I is accordingly disposed of. 393. Yeah, I is accordingly allowed and disposed of. Allowed and disposed of. Then with regard to 438. 438 has been already,
No, otherwise
we
it's
don't,
already
I think
disposed.
this will take care of,
This will take,
this will take. So it has been deemed to be suspended.
yes.
Just may I take permission to leave the court first, I have another writing court number.
No problem.
Thank you.
Yes, so now is your case.
Here in this case, Lordship, if your Lordship see, the main accused, prime accused is one Molodas.
Huh?
Main accused is Molodas. Molodas. During investigation, he died.
473. I 473.
That Molodas,
Molodas not here.
Molodas already during investigation, he died. Lordship.
Oh, okay,
He
right.
died. He admitted before the police as well as before the PW1 that he took the vehicle and the deceased with him and thereafter he killed. He even led the police team to recovery of the dead body and vehicle, those things are there. These things relates to Molodas. And now after his death, what happened, Lordship, that PW3, brother of the deceased, he improved his statement from 161. In 161, he nowhere says, even he admitted in cross-examination, that he has not stated before police that he heard Molodas saying that this present applicant was along with Molodas. He admitted that part, Lordship. I am straightway taking Lordship.
That was, IO was confronted with that.
Lordship, he admitted.
No, IO, what did, what did the IO?
PW3 admitted that he has not stated. Therefore, confrontation is not
No,
required.
huh?
They are not required. If he
Agrees to
deny,
What?
Yes.
What the contradiction is,
Then
then no longer it's required. Only when he says. that
Only
I'm
when he
not
denies
sta-
that.
Denies that,
if he
then
denies, then it is required. Then page 31 of my Lordship may kindly see that part.
Page?
Page 31 of my IA. This is a cross part of PW3. Cross for accused Ibrahim Ali. That
Page
is because-
31.
Yes, sir. Not paper book, Lordship. that's
Okay, not paper
IA,
book.
IA.
Well, actually, this paper book is in the IA, that's fine. And, okay, page 31.
Lord.
Yes,
Cross for accused Ibrahim Ali.
yes.
I did not state before police that Ibrahim Ali was present along with Moloda, Sagar Ali, Kasem Ali, etc. as because I came to know about the said track later on. It is not true that I deposed falsely. And rest of the witness, that is Lordship, PW 9 and 11. They say they heard Moloda saying about this applicant while he was in police custody. So if he is in police custody, that extrajudicial confession will not be treated as evidence. Only that much evidence against the present applicant. And if your Lordship see the evidence of PW1.
No, so where were you? What is your story?
My story is that I may be involved along with the other two in stealing the car, but not in the actual crime, Lordship. Because in the judgment also it is said that 379, well, I was convicted along with them, they were also with me. Because main prime accused died, so therefore the other interested witnesses, they developed their case and implicated me, Lordship. Because prime witness Molodas, he died during investigation. In 161, nowhere my implications are there. Even PW1, who initially apprehended the prime accused Molodas, even he says that Molodas.
So your conviction is based on PW3's evidence.
Yes, PW3, 9 and 11.
And
All
what
said
about,
during Lordship, while Molodas was in police custody, he confessed. So that confession will not, section 26 will come, Lordship's husband is also there. And even if your Lordship said PW1, he categorically said that he was the first person along with others went to apprehend Molodas after getting the information. And Molodas said he borrowed the vehicle, he killed the deceased. Nowhere he says about this present applicant. PW1 Lordship may kindly see. Page 17, 16, your Lordship will find third line from bottom. Page 16,
page 16?
Lordship.
Yes,
space, last four line, Lordship, may I only say.
Yeah,
After a few days later, I learned that Molodas, page 16, fourth line from bottom. I learned that Molodas had stolen the car and had been hiding in Dimapur for several days, and therefore I went to Dimapur with several village boys, and we had caught Molodas. When we picked up in the car, then he confessed that he took the boy along with the vehicle and he killed the boy. So it is related, he said about himself, not with regard to others. In his statement, PW1, my name is not there, and even therefore, in page 18, your lordship will find that cross-examination for this applicant was declined. Because there was no intimating statement against me. And now if your lordship see the evidence of PW9, he says that he had during while the accused was in police custody. And even while convicting the present applicant lordship, the learned trial court considered the 161 statement of co-accused that your lordship will find in the judgment paragraph 47. That in my humble submission cannot be lordship. Paragraph 47 of the judgment lordship. Co-accused statement that too recorded under 161, he died, so. Paragraph 47 of the incident.
Because he died.
so yes, madam, but
In fact, yes, the evidence against the present applicant is only to the extent that PW1 had heard it from the Molodas, whatever he had said. Now, I'll just tell what are the evidence against him. That is PW1, of course, what had happened is that he went to the taxi stand, and the taxi stand there, the people said that Molodas had hired the vehicle. Then he went and and that Molodas was hiding in Dimapur. They went along with some boys. Molodas was apprehended. And while questioning, Molodas confessed that he took the victim, killed him. Of course, that time he did not say about the applicant. That is, of course, but then he said he took the victim, killed him along with others, and then he can show the place where the victim body was lying. And the victim's body was recovered.
That is at the instance of Moloda.
At the instance of Molodas. Thereafter, what happened? The vehicle. Informant was also informed that the vehicle was sold in Naharlagun. And then the vehicle was also seized along with the documents.
That is
And
from different person.
yes, this is Molodas then said that the applicant was with him. Informant, when he searched for the vehicle, then Molodas said that applicant was with him while hiring the vehicle. Now, this can be taken as an extrajudicial. Of course, if police is there, I have to see, because PW1, Lordship will just see his evidence. Where he said about the present applicant. One. नहीं कोई से We learned that the vehicle was sold in Arunachal and a mobile.
How
phone
does,
was-
how does PW3 say that Ibrahim was present in the vehicle when the person was, when his brother was killed?
PW3. Yes, PW3 said, Molodas told him that others and others that applicant was present with them at the time of occurrence. As you will see PW3, he stated the applicant was present in the vehicle when his brother was killed and all accused persons stayed at the applicant's place after the incident,
They stayed at his house.
has stayed at his house. So,
So that fact he came to know, he said that he came to know from Molodas
ha,
while he was in
Molodas.
police custody. And those facts he did not disclose during investigation.
क्या नाम क्या है? इब्राहिम अली ना? Qasim Ali, Ibar Ali, this is at page 17. Car was recovered in Arunachal. Molodas said that Qasim Ali, Ibrahim Ali, Sagar and the women were with him. We found a dead body after recovery of the vehicle. Now there is nothing to show that this statement was made in the presence of the police while he was in police custody.
So for example, he admitted that he has not stated during 160.
The police arrested so and so for Ibrahim, no. It is not Ibrahim Ali was, I did not state to the police that Ibrahim Ali was with Molodas. No, this is in the context of different. Now, he did not state that Ibrahim Ali was with Molodas, but the statement in his chief is Molodas told him that Ibrahim was with him. So not to that extent, it is not contradicted. But Molodas had told him that Ibrahim was with him. Because all evidence are only to that nature, of that nature that Molodas said that Ibrahim was with him. And they were at Ibrahim's place after the incident was finished. And PW9 had also said, applicant part of a group, PW9 had also said that Ibrahim Ali was the part of the group. 9, it's a short statement, Lordship will see. I have lost my son. Oh, this is the father.
Page 49.
Page 27. PW9.
9 is 49.
No, this is, oh, this is the paper book I'm holding, actually. And the same thing, Lordship will see to feel.
Ah,
We could find so and so. And Ibir, Kasir and other 5 boys were involved in the incident as confessed by Molodas. I was present when he confessed all those things before police. So that, of course, that will again not count. There was a planned murder. That I am skipping because I think police.
now
was
let
there.
us see 12.
Now, yes, even 5. 5. 5 had also said the victim had been to her place.
11 also says about confession but death in presence of police. Confession by Molo.
11. 11, so. Okay. 3-4 months police brought Molo, he confessed before police.
5
then-
is, 5 doesn't say anything.
No. 5 says only that victim, she stated that 3 days before the incident, victim had been to her place at Kuthari along with Molodas. And victim told that he has passengers in his vehicle, only to that extent.
That is neither here nor there.
So what we are left with, the PW3 statement only.
Yes.
PW9 I'm discarding, PW2. PW2, the mother of the victim had also said some similar statement.
12 also does not say anything.
Huh.
So we basically were left with PW 1 and 3.
One said nothing against him. And only PW3 that he admitted that he did not state before police. And from his statement in chief lordship, or it is also there that he heard while he was in police custody. That Molo does.
PW3, I'm just reading out again.
Yes.
My younger brother, the incident, I know all the 6 persons, the deceased was my younger brother, is my father. Incident took place so and so. My younger brother took the Indica vehicle, number so and so, standing in the name of the father and left home as a vehicle. Since he did not return, a phone call was made to him. A phone call was not picked up. Thereafter, the phone started ringing. Following day, we came to the PS, gave the information. After that, though we were searching for him, we could not trace out. We caught Molodas in Dimapur. We brought him. We means not with police, he with other people. We brought him along and handed him over to the police. Thereafter, Molo said that he had killed my younger brother and thrown his dead
After
body.
handing over him to police.
That's a way. 5 persons went to Tezpur from Golaghat by hired car, and Molodas was supposed to return by the car. Thereafter, Molodas led the police and showed the body. I'm the member of a family. We were shown located. So we found the dead body of my younger brother 2 months and 17 days. Only the skeleton was there. Okay, recognized by clothes. Car was recovered in Arunachal. Molodas said that Kasem Ali so and so were with him. We found the dead body after recovery of the vehicle. We found the dead body after recovery of the vehicle. That means the vehicle was recovered earlier. And during the recovery of the vehicle, Molodas had made these statements. Now, whether he is in police custody, things are not clear. We found the mobile phone of my younger brother at the place. When the mobile phone rang, Molodas and
So
others.
out here, our vehicle was recovered at Arunachal.
Huh.
Molodas told that Kasem Ali, Ibir Ali, Sagar Das, and one woman were also present with him.
Hmm. Thereafter, Lordship, we found the dead body after recovery.
Right.
Dead body was recovered after he was handed over to the police. Then we became convinced that the car has been driven towards that direction. My younger brother went to Naharlagun and stayed there. While we were searching, Lordship will see the third page number 18, the last paragraph of his examination in chief. Then we became convinced that the car has been driven towards that direction. This is before police came into the picture. Then my younger brother went to Naharlagun and stayed there for 10 days. While we were searching for the car there, he learned from some drivers that a Indica car without number being driven out there. On receipt of information, I went there. Going there, I found the car.
This is from, we are reading from the paper book.
His
Okay.
deposition of PW3.
Okay, okay. So you are changing the words here and there. Yeah.
No, I'm placing the
Okay.
third paragraph. Going there, I found a car. Thereafter, I took the
The
OC.
sunshine gold color and without number
Ah.
plate was fine.
Yes.
Okay.
And there we found a person who was using, on being asked, he said car belonged to him. After that, he was brought to the police station. There he took the car from Kasem Ali, contacted Kasem Ali through Ayub Khan. He said that he purchased it for so and so. Earlier paid so and so. We identified the, except for the number plate, other things of the highway intact, pollution. Thereafter, the police went there, and after bringing the vehicle with them, the police put it under our custody. Was recovered. When my younger brother was assaulted, Ibir was in the car. The entire party stayed in the house of Ibrahim. We learned this from the members of the family of Ibrahim. So the entire party stayed in the house of Ibrahim. We learned it from the members of the family of the Ibrahim.
Then how come they knew, how come he knows of Ibrahim being present when the younger brother was killed?
It is only from Molodas. And whether that statement he came to know when Molodas was in police custody is not very clear. Because they found Molodas first. They handed him over to the police. And Molodas, since he had expired, his 161 statement will be relevant. Because I don't have any judgment to back it. Section 33 will not come because section 33 one has to be cross-examined. Not come. 32, I tried to bring it within section 32. 32, one is cause of death. That will not be. Lordship can see it. Section 32, clause 8.
Probably that will not come because he is one of the accused and for taking his evidence as a
32 of?
Evidence Act.
that he has to make approval, Lordship. Their approval part is not there to take his evidence in the record. Lordship.
He died.
But he is one of the accused.
Section 32. 32, one will not come, of course, in cause of death, it's not that. But two, of course, again, the statement made by such person in ordinary course of business. And in particular, when it consists of any entry or memorandum made by him. Because 32 includes all the statement of any relevant fact. When the statement is against the pecuniary, it gives opinion. 8 perhaps will come. Is made by several persons and expresses feelings relevant to the matter in question. I'll have to do some research on this, whether statement of an accused before police officer and who is dead before he could be police officer.
I don't
and
know, statement of co-accused, can it be admissible?
Only a weak piece of evidence.
Hmm.
Confession of a co-accused. It's a weak piece of evidence. This is not even confession. This is a statement before police. In his statement before police, but he had stated that it was the applicant who actually had is the kingpin rather.
Who had stated?
Molodas in his 161. He stated that that applicant along with one Kasem Ali hired the vehicle of the deceased. And it was the applicant who along with Kasem Ali dragged the body of the victim and finally joined the entire group. Who killed, of course, he did not say. I can see the 161 statement, and if it is at all relevant, again, the question will be whether it is at all relevant. Therefore, it is seen that he dragged the body, he along with others threw the body in the river, and vehicle was sold, mobile also changed hands. What's the case doing? What of the 161 person? No. Huh? Tomorrow time.
Okay, we'll fix another date.
Lordship. It's a big case, Daddy. I'll have to.
Yeah, let's fix another date.
The main that PW3, and he admitted that he has not stated before.
Let us-
Molodas was immediately handed over to police in the evidence of PW1 as well as PW3. And if his statement is during police custody, Lordship judgment is that that will cover my case also.
Right, I heard Mr. A. Amit, learned counsel for the applicant. Also heard Mrs. Jahan, learned PP. Matters adjourned for a week.
Does not fix date.
And leaves the matter on, give a date after a week.
Follow the statement.
When do you want?
Lordship, any date, one, I'll just see this, that will suffice. 11th, 11th.
11.
No, the statement is, I don't find it in the case, I'll have to check.
In the, this is in IA
No, in the case.
four
diary.
seven three, IA 473, huh? No problem. Yes, you can come. Your maintenance. Yes, what was the client saying?
Saying that my lord, today he has deposited 3,000. And my lord, the rest amount, my lord, he will try to deposit 15,000 within this month. And next 15,000 will have been 15 days back.
He will not get.
Just before your lordship, my learned made a statement before this, whether within the 30, he will
You have
deposit
to give, you have
30,000.
to give 15,000 for August
30,000 at a time, yes, sir.
and 15,000 for September.
September.
As, this is as per your prayer.
Yes, sir.
In fact, we had given the installment plan. You could not comply with it. Then we asked you to make an installment plan. We have now made your installment plan. The manner in which the area maintenance has to be paid. Now you are not even following your area installment plan. And what was the client saying? That some agreement has been made with the wife?
Yes, my lord.
What?
मेरे वर्ष बात किया था जब मैं दे नहीं पा रही हूँ मेरा पैसा मैंने लोन लेके जो जितना सका दिया यहाँ पे 1 लाख रुपया दिया इसके बाद मेंटेनेंस भी देना तो बोला मेरा मम्मी पापा दोनों ही तबीयत थोड़ा बीमार है मैं कैसे दे पाऊँ तो मैं बोला आप पैर पकड़ के माफी मांगा है तो मुझे माफ कर दी
No, lordship, that is not true. You are not true. Pardon to them.
नंबर भी
At
दिया
all.
सर मेरे सर का
He's falsely submitting before this.
All this happened.
Matters, Lordship, and
Yes, no objection, I think.
No
there is 5 days delays only.
Five
I
days,
heard
no?
Mr.
B. Haldar, Lord.
B. Haldar, learned counsel for the applicant who submits that there's a delay of 5 days in filing the appeal against the impugned judgment dated 29/5/23 passed by the learned sessions Judge Charadio in sessions CHA. What is CHA? Sessions case number, sessions bracket CHA, right close, case number 15 of 2020, convicting the applicant under section 302 IPC. Who submits as Jahan, learned additional PP submits that she has got no objection to the delay being condoned. Pustam. In view of the above, the delay is condoned. I is accordingly disposed of. Before that, you say, registry to register the appeal and list the same after a week. Okay. I is accordingly disposed.
20
There's also a delay.
Yes, no objection.
No objection.
40 days out here, huh?
No, no
43
objection.
days.
Huh?
43 days of delay.
43 days.
No objection.
For 43 days, then this out here will be again the impugned judgment dated 17/5/2023 passed by the learned sessions Judge Dibrugarh in sessions case number 258/2014. Right, this is a wait a minute. Item,
20. Toshniwal.
this is against a notice will have to be issued, I think.
This is FOXO.
No,
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 Lordship, this is a
leave to appeal against acquittal.
Oh, this is an appeal against acquittal.
preferred by the victim.
Oh.
Under
Oh, it
Provide
doesn't
to-
look that, it's an statutory right, so. But then there is a delay again.
There's a delay, that's what. So-
Under section 372.
So we can.
Condone the delay. no?
We'll condone the delay,
Lordship.
but this is for what, leave to appeal? No, this is for
Leave to
delay.
appeal is not required.
This, whatever, this is what have we said? That, just I heard, Mister. Yes, what is your name?
I have not filed any appeal.
Yes,
So Deepa Mani Soikia.
This is by, who is this person?
Lordship, he is the victim, father of the deceased. Who was murdered.
Father of the deceased.
Yes, your Lordship.
I'm not aware whether any state has filed
In
any
fact,
appeal.
Lordship, as per the information, the state has also preferred an appeal against acquittal.
No, you get the
Your
information.
Lordship,
We'll take it up at 2, you get the information.
your Lordship.
Don't pass on your.
21
Deeply.
21 now. Yes, sir. LCR is not here.
this is listed for first time.
Oh,
First time.
listed for admission.
Give me
oh,
the,
you're right,
give me
you're
the
right.
main appeal.
I'm not here.
Give me the main appeal. Right, heard, Mister?
He has it.
A Hazarika, P Hazarika, yeah, P Hazarika, learned counsel for the appellant. Who submits that the impugned judgment and order dated 14/8/23 passed by the special judge Lakhimpur in special bracket NDPS right close, case number 1/2018, convicting the appellants under section 20B2C NDNPS should be set aside. Admit the appeal, call for the LCR. Miss
M. Decca.
M. Decca. Here, what are you?
I'm on behalf of STKL.
Accepts notice on behalf of Mr. S.C. Kal, standing counsel or
DR.
standing counsel for the respondents, for the, accept notice on behalf of respondents number 1 and 2. That should be say, standing counsel for DRI, accept notice on behalf of respondents number 1 and 2. And this is the matter after 4 weeks. Then in the, there's a 389.
Yes.
Okay, right. Miss
M. Decca.
M. Decca appearing on behalf of Mr. SCKL, standing counsel DRI, is granted 4 weeks time to file written objection to the application for suspension of the sentence and grant of bail. This is the matter of 4 weeks.
তেতিয়া চালে হয় নহলে নহলে প্ৰেক্টিকেল কম্পিউটাৰ চাই পঢ়োৱা আছে প্ৰেক্টিকেল চাই ন
Hi, Krishna. এটা সেই লেপটপৰ আছে এইটো মই এপিল ফাইল কৰিছো মই পাহৰিছো Nothing has been done so far.
Appeal admitted.
No, it's not even registered. I think even my LP is not registered.
What to do?
As far as his appeal is concerned, Lordship can condone the delay and get it registered. My appeal will come in course.
So that you get a handle.
I have filed it on 3rd of July
Will notice be required out here?
here.
Hmm?
Not because it's a statutory appeal. Leave otherwise he doesn't require. Only condonation.
That's what condonation.
Perhaps to the accused it will be required.
That's
Let
what I
me-
think. Item 20. You're right. This is an appeal, this is an application for condonation of delay of 43 days
43 days, Lordship.
in filing the appeal against the impugned judgment dated 17/5/23 passed by the learned Sessions Judge Dibrugarh in Sessions Case number 258/2014, by which the respondent number 1 has been acquitted of the charges under section 302, read with section 120B, capital B, IPC. Issue notice returnable in 4 weeks. 4 weeks. Ms. S. Jahan accepts notice on behalf of the respondent number 2.
In my case, there is no delay. I have filed it in within time.
Oh, we have no delay, only leave.
Only this day. That has not come up. I'll see what has been done in the office.
Applicant to take steps for service of notice upon the respondent number one by register post within 3 days. This is the matter of the following.
Deeply offense.
No.
Manoj, here I have filed an application under section 391 CRPC manner for reduction of pericial evidence on detection of certain facts manner, which were not in the brought in the record manner, either due to minor mistake of the lawyer. So my that this notice will go to the informant.
You're the appellant,
Yes, sir.
convict,
My lord, appellant.
accused appellant.
20 years now.
Okay, in the IA, you heard Mr. R.P. Sharma, who submits that additional evidence needs to be recorded in terms of section 391 CRPC. Issue notice returnable in 4 weeks. Ms. L. Jahan accept notice on behalf of the respondent number one.
And regarding two minor, can she inform the Thana through Thana minor?
No, this is POXO matter, so I.
No, by rest of us also I'll check.
No, you have to submit to the registry will give it to her.
Yes.
Full stop. Right. The applicant shall submit copy of the application to the registry, who shall forward the same, who shall give the same to the additional PP, Miss L. Jahan, to be forwarded to the concerned IO/OC of the concerned police station
Mariani police.
for
Mariani.
Moriani Police Station for delivery of the same to the respondent number two. A report shall thereafter be given by the concerned IO/OC of the concerned police station. This is the matter of the police.
Item 23 is the legal aid matter, your lordship, and the IA is for condonation of 59 days of delay in filing.
No objection.
Right. Heard Miss
S. Sharma.
S. Sharma. S. Sharma Hazarika.
Yes.
Miss S. Sharma Hazarika, legal aid counsel, who submits that there is a delay of
59 days.
59 days in filing the appeal. Ms. S. Jahan submits that she has got no objection to the delay being condoned. On considering the grounds for the delay and keeping in view the submission made by the additional PP, the delay of 59 days condoned. A registry to register the appeal and list the same after a week. I is accordingly disposed.
Oh, pleasure, lordship. This is that matter where your lordship had ordered for FSL examination on the spermatozoa that was found in the undergarment of the victim.
I don't remember.
Yes, yes. Lordship, in fact, remind us the issue later.
was on 6/6/23.
Okay, let me see. 6/6.
Yes, sir.
Yes,
Thereafter,
The
let's say
report has
on
come.
1st August,
What's-
another order was passed as report was not received.
Report is there, Lord.
Where?
That
That's
report
it.
is
That
written
yellow
pink
flag.
or what, a yellow flag perhaps.
Acha report. Hi, sir.
A report says that they are yet to do it, the articles were in the custody of police or something, lordship can see. They spoke of the trial.
So how do we know? Now they feel that how another attempt may be made is the remnants of exhibit preserved in proper condition.
In the judgment, otherwise, the direction was to dispose it off
In due course.
in due course, yes.
So we have to ask the report from the trial court as to whether it was disposed of.
Lordship, perhaps it's a bit
Samaguri
police.
PS.
What I
think-
can read, they brought it, so they took it. Samaguri police took it.
So this is written to the deputy registrar.
By the. Yes, cannot be.
So it has been most probably destroyed.
But can
But we need some
proper report,
clarification.
yes,
Yes.
that it is destroyed.
And whether, let's say, it is kept
Huh?
proper, whether it is kept under proper condition, let's say.
Naturally, it's either
That's
kept or not kept.
That's it,
There's
that's-
only two things.
that's-
There cannot be a third issue.
Nagaon.
No.
Dispose of in two thousand eighteen.
Of 2015,
Many years.
December 2015.
Okay, right. Heard Miss A Devi, learned legal aid counsel. And Miss S Jahan, learned PP. The present, no, this court in its order dated 6/6/23 have directed the FSL Hanapara, Kahili Para -1 to make an examination with regard to exhibit, the exhibit numbers are here in the 6/6, 4 of them, exhibit numbers so and so. With regard to whether the spermatozoa found in the above exhibits matched each other. In response to the same, the director in charge FSL Kahili Para has written a letter dated 11/9/2023 to the deputy registrar of this court, stating that an attempt shall be made to make an examination if the remnants of the exhibits were preserved in proper condition. In that view of the matter, who is to find out now?
Either
No,
trial
no,
court or
Don't
the-
say in that view of the matter, just say in the impugned judgment dated 24/4/2018 passed by the special judge Nagaon in special case number 48(N) of 2016. Arising out of Samaguri PS case number 472/2015 under section 302 IPC. Read with section 4 of the POCSO Act 2012. The learned trial court have directed that the seized materials should be destroyed. In that view, first up, in that view of the matter, the learned trial court,
trial court or
the learned trial court, the registry shall obtain a report from the learned trial court as to whether the above exhibits have been destroyed.
and if it is still there, then no.
And if it is still there, whether it has been properly preserved. This is the matter on. After vacation,
Registry had to do after vacation.
this is the matter of.
Date, let's.
Date, give a date.
After vacation. 7th November,
Okay.
7
Much
November.
of less.
Finish.
No, list is exhausted. Lordship has a single bench
Oh, I've got single bench date.
of last. Oh. Time Simon লোকৰ কথা আছে।
But he's on leg.
সেইটো কাৰণে বৰ বেয়া লাগে,
Hello, title নাজানি। সি মানে যদি কৰিছে তেতিয়াহলে পাৰ্মিশ্যন পাব ন।
তেওঁৰে জুনিয়ৰ আছে ন?
সৰু ল'ৰা এটা।
মেইন কথাটো নহয়।
সৰু ল'ৰা।
All right. There is a request from the PP. If the restaurant gives now, I'll call that. If we get, if we have.
No, I'll, court number 17, next I think is mine.
I'll take that.
I'll be here to go. Okay.
Number. Oh,
Yes,
Well, 4 witnesses has been examined.
Four have been examined. Yes,
My lord,
this is a commercial quantity, Mr. Murray. So what to do?
not even assuming my lord.
Huh?
As per the, my lord, allocation, my lord,
As per?
as per the allegation, my lord. So, the contraband was seized in the highway.
Huh.
So I was riding on the fateful day, I was riding a scooty,
Huh.
even for a normal, my lord, as a normal understanding, my lord. If it is 26 kg, how can I ride if I'm involved in a?
Why not? 26
No,
kgs
no.
in a scooty, why
Madam.
not? I have got a scooty at home
Yes,
and I carry this ration rice, 50 kg ration rice in the scooty. What, this is only 20 kgs of ganja, what is that?
It can come in a.
Yes, no, no,
But itself.
I'm telling you, I've got scooty at home. I have carried a 50 kg bag of rice in
No,
my
I-
scooty.
lordship, what I'm trying to.
This
explain.
here,
Yes, lordship.
then what do you mean? This 26 kg, why not? Why is it not possible?
The quantity is huge, my lord. Because ganja is very lighter.
No,
Just
it
assuming,
depends, it
but-
depends.
As per the Caesar list, lordship, with due respect, my lord.
Where see the season list?
Caesar list, lordship, may kindly come to page 27.
Yes,
Place of Caesar, my lord.
yes,
Place of Caesar.
yes.
NH 27 near J Kuru Dhaba. Time was seized of at 7:45 p.m.
Correct. 5 plastic wrap packets suspected to be ganja. We do not know how big the plastic. You
No.
see, it depends upon how the packing is. You see, some ganja that used to be caught by the customs earlier when I was a lawyer,
Those are compressed.
compressed, packed tight.
Yes, ma'am.
So
Like a
it'll
cake.
come like this, it'll come. So it is not, Mr. Council, that
And-
just because 26,
No, it's
and there will be a big, huge bag. Whereas, show me show me
no,
some,
no, see, here, my lord, here, it was not seized from the vehicle, which I was driving. The vehicle is set serial number 2 in the list of Caesar. Now, here in the witness, Caesar witness, there are 3 witnesses, independent witnesses.
yes,
And these independent witnesses does not corroborate anything relating to prosecution.
we don't know.
No, I have enclosed, lordship. If I can refresh your memory, lordship, last occasion I have read regarding the deposition of those witnesses. They does not know anything about, they were called upon in the police station and the board sign upon on those papers. Except apart from that, no allegation, no any materials against me. In fact, they could not know they have not know anything about the incident.
In your house also there was some ganja.
Yes.
And that was the allegation, yes. Some grams has been. How many grams?
My submission is trial is going on a submission phase.
Page
And-
29, 180 grams.
The commercial quantity. Regoes of 37 will.
Where is the evidence? Where is the evidence?
My lord, evidence
You have not annexed.
starts from my lord, page 54, my lord. Annexure G.
So PW1 simply says he was called upon in the police station and he was asked by the police to put signature and accordingly he signed. That was his deposition.
3 and 4 declared hostile.
What about this,
Ayub,
so Bishnu Sharma, his evidence is neither here nor there. This does not support prosecution. Correct?
Yes.
Then, evidence of Ratan, he declared hostile. What about Ashok Kumar Nath?
As for the
Was Ashok Kumar Nath examined as a
Just-
witness?
charge sheet page 42, this is a list of
No,
witnesses.
no, Mr. Counsel. You said there were 4 witnesses have been examined. Show me the evidence of 4 witnesses.
3 witnesses I have enclosed,
And who is the
And-
4th?
close. PW2, I have not enclosed because of the fact that it was a forensic person who examined the contraband. So he was, as I was instructed that his evidence has been recorded through video, VC. So
PW?
PW2. So
What about this Ashok Kumar Nath? His evidence has not been recorded as on date.
Ashok Kumar,
He's a witness.
Asu development.
No, page 27, go to page 27. Signature of witnesses, number 2.
Ashok Kumar.
Actually, it should have been Asu Devnath.
Asu Devnath.
Yes.
Oh.
This is a type copy. He has been declared hostile.
What does the charge sheet say?
Justice say, my lord, recovered initially, those 25 pages were recovered from him. Subsequently, he led to the house, from house another quantity recovered.
This NK Murray, what is this? What name is this?
My lord, my name is Kamchu Mori. N stands for my father.
Okay.
And
Murray is what?
Mori is
What,
my son title.
what tribe?
Lotha.
Lotha.
Yes, my lord.
Murray is,
Lotha Naga.
Lotha Naga is Murray.
Yes, my lord.
I don't know, there's not, you see, 26, you have got to show that there has to be a reasonable belief that you did not do the crime. Why don't you wait for the trial to finish?
No, my lord, my humble submission, my lord, with your respect, my lord, kindly come to page 53. This court, earlier occasion, my lord. The order. Last last para, my lord.
Yes,
In view of the fact that consideration of charge was to have been completed on 3/2/2023, and there is a likelihood of the trial having started. This court is not inclined to grant bail at this stage.
yes,
That was the, my lord, with due respect, my lord. Court says that because of trial is to be initiated, so at this stage, bail may not be granted. So as per the special, since NDP is a special act, with due respect, my lord, there is a part under section 37 of
Correct.
NDPSL.
correct,
It's unlike the general law.
correct.
Bail, jail is the rule, bail is an exception. Here in this case, there are two conditions.
Correct.
Prima facie, number one, the prima facie, no case has been,
The court is
Against me.
satisfied that there are reasonable grounds for believing that he is not guilty.
he is not guilty. Secondly, no likelihood of committing.
First cross the first bridge.
Now, apparently in the, what the Caesar list, what the independent witness, what they have made as Caesars witnesses. Those who have witnessed the incident at the place of occurrence, they have clearly deposed in the court, we do not know anything. What more is required, my lord, on part of the me that there is prima facie, no case against me. Even assuming that
So,
I-
but if they declared hostile, why can't? Just because they declared hostile, you mean to say there's no case against you? Is it?
no, they were not aware, the examination says,
They have been declared hostile.
yes, two
And
have been
what is
declared.
the value? Then what is? Then isn't the evidence of the other witnesses enough? What
Main,
about the police witnesses?
main informant, the Iowa has not been examined till now.
That part is, that will be at the time of trial, it will come out. Now, whatever is material on record basing on that, prima facie, no case against me. Secondly, as I submit that since there is a part and condition, second condition, I'm having no criminal record. And Lordship, kindly come to citation,
Yes,
I just have realized the first citation one
yes,
to 1984, para 5 and 7.
yes,
I highlighted, my lord, I may just allow to read.
yes.
We fail to understand what the learned judge of the High Court desired to convey when he said that once a prima facie case is established, it is necessary for the court to examine the nature and gravity of the circumstances in which the offense was committed. If there is no prima facie case, there is no question of considering other circumstances. Prima facie.
Mr. Counsel, this does not deal with 37. The judgment
Yes.
is basically with
Of course.
439.
Now,
So
next
that's
line,
a,
next line may be relevant, my
yes.
lordship.
yes,
In case, but even where a prima facie case is established, the approach of the court in that matter in the matter of bail is not that the accused should be detained by way of punishment, but whether the presence of the accused would be readily available for trial.
Mr. Counsel, this is not relevant to this case. This NDNPS case came into play came into existence in 1985.
Now,
Correct? When did it come into effect?
now Lordship may kindly come to next
Huh?
citation.
And when is the judgment that you're relying upon? Judgment you're relying upon is of 1984.
Yes.
Then it has nothing to do.
No,
and
no,
there
whether
was-
my
And
attendance,
there was no question of the section 37 being considered. This has no relevance to your case.
no, whether my attendance is secure, whether there is.
No,
likelihood
that
of-
is not. We
that
have to,
may also be examined. And so far, section 37 judgment,
let us
Lordship,
see.
light law reported, my lord.
Yes,
Para 10, 11, 12, 13, 14, 15, 16.
yes, yes.
And the conclusion part is of.
What is the name?
Para 10, Lordship.
Yes. Now let us see the first thing. Yes, para 10, okay?
Yes. That was the provision
Yes,
quoted.
that para 11.
That was, my lord. In this case, as it stands, the appellant has been in custody since 2015.
2015.
Yes,
When was bail granted?
bail was granted in 2023.
8 years.
23.
8 years.
Yes.
Yeah, okay, now let us.
No,
see.
here, no, that 2015 is regarding,
Regarding what?
yes.
In this
Yes.
case,
Yes.
34 more witnesses yet to be examined. That's why court said that
8
total
years.
incarceration is not.
Now, in
permitted.
your case, you were arrested when?
I was arrested,
July 22.
yes,
And how many years have gone since then?
37.
Uh, How many years have gone since then?
Lordship.
How many years have gone?
Today
since-
is 423 days.
No, how many years? I said, I'm not talking about days. I'm saying how many years? 2 years, 3 years, 5 years? How many years has gone since your arrest?
For one years and
1 year.
2 months.
Not only the period of detention, my lord, the progress of the case that has to be looked into. Here, the case is progressing in a sufficient pace, my lord. And
And-
in that particular case, which my learned friend is relying, my lord, 34, if I am not wrong, my lord, 34 more witnesses yet to be examined, my lord, in
And-
8 years.
And my lord,
So outside there are nine witnesses,
kindly,
Out of 9 witnesses were already.
for
examined.
example.
in this judgment, the parameter has been laid down. And my lord, can you come to page 70th of my petition annex?
No, what has been laid down in this judgment? Let us see. Please go to the relevant paragraph.
Prolonged incarceration is.
Huh?
Prolonged incarceration is violatory of Article 21. That is the main reason.
No, so let us see. Which paragraph he wants to rely upon.
My lord, para 11 is start, my lord.
Para 11 is, there's a difference between your case and this case. Now, in para 11, there was difference of 8 years.
Then para 12, lordship.
After
This court has to therefore consider the appellant claim for bail within the framework of NDPS Act, especially section 37. In Supreme Court so-and-so cases versus so-and-so, this court made candidate critical observation which have a bearing on the present case while dealing with denial of bail to those accused of offense under NDPS Act. On account of this strict language of the said provision, very few person accused of certain offense under the act would secure bail. Now, to refuse bail on the one hand and to delay trial of the case on the other hand is clearly unfair and unreasonable and contrary to the spirit of section 36(1) of the act, section 309 of the Code of Criminal Procedure and
so now, Mr. Counsel, in the case before the Supreme Court, the person had been in jail for 8 years.
Yes.
And there was a delay in the trial. Now, in your case, charge has been framed in February. Already 4 witnesses examined, only another 5 left. Where is the delay in the trial?
during 1 year only they could examine 4.
Thank God. Not even 1 year. 1 year has not passed.
8 months.
Frame was, judge was framed on.
February.
February. My lord, no, 30-10-22.
3/2/22.
You have written it.
Yes, so 3/2/2 means what? February
A search frame on 3/2.
23.
23.
This year, 1 year has not passed. 1 year will pass only in February 24. 1 year also has not passed.
My lord, prima facie at this stage, my lord, only witnesses, mainly is the independent witnesses. Solely on that basis, my lord,
So you mean to say, unless there are private witnesses to support the case of the enforcement agency, only then can a conviction be made. Is that your case?
no.
If that is not your case, then
Pardon,
you-
Firstly,
if
as
you
per the-
said yes, you had a point, but if you
As
say
per-
no,
As
Yes,
per the section
you're supporting
35,
the prosecution.
section 35 and 54. Of course, I'm not at this stage on appeal, but section 35 and 54 clearly say first the prosecution has to prove. Then only party will see.
Sorry. Section 35 is a reverse burden.
Yes.
You are presumed to be guilty in 35.
No, 50, it has read with 54. Preponderance of probability will apply to me. Firstly, the prosecution has to prove beyond reasonable doubt.
No,
was seized from
no,
possession.
you have got the wrong understanding. The only thing the prosecution has to prove the foundational facts, that's
Yes.
all.
That was seized for me.
Yes.
But here apparently seizure list is clear.
The witnesses are still there to be done. There are
No,
still
no.
another 5 witnesses.
Witnesses does not say so, Your Lordship. And this court, with due respect, Lordship, kindly come to last annexure,
Hmm.
page 78.
Yes.
This court on a similar CJ that my lord allows the accused persons.
Yes.
Relevant portion, my lord, page para 7, page 79, then para 11.
Yes. You see, another thing, Supreme Court has got the power under 142. We don't.
No, this court, Lordship, this court pass an order in this case.
But actually, all cases are different. That cannot be applied in bail. And in Mohit Agrawal case, my lord, it has been made clear that while dealing a commercial quantity and court while taking might of satisfaction that he is not guilty under section 37, court should not weigh the evidence. Court should not go into weighing the evidence at the bail stage. Right?
You see, to do
And, my lord-
complete justice, Supreme Court has the power. Now, we do not have 37th is binding upon us with all its might.
And my lord, it's another aspect, my lord, my wife, my lord, is very serious patient.
That
My
is
lord,
a-
he could not go even for recheck up because of the incarnation of my husband. I have annexed the document.
Why?
My lord, kindly see the page 61, the medical documents, 61 and 63.
That cannot be found.
Ulcer like tumor is a
It's
part.
ulcer to everyone.
Tumor like it's
Tumor.
operation in the breast part. Another part also getting disturbed.
RBC,
These-
HbA1c is your sugar, vitamin D.
Recheck after 3 months.
CC.
It is not a serious issue, man.
17/5/22, I was discharged. Page 63.
What date is this? Page 61? What is the date?
Page 61, my lord, can you come to page 63? That will be clear. Date of discharge is here, my lord. In the up. Top right side.
So,
17/5.
this is date of discharge is, you have been discharged in May 2022.
After undergoing,
May 2022, and you were arrested when?
not, kindly come to
Why
after
didn't
3
you?
months,
Huh?
page 61.
Then,
Advised to recheck after 3 months,
then did you go?
strictly medical.
And why didn't you go?
No,
Why did your wife go?
nobody is here to take care of me.
What is there to go?
No, I'm still in problem. I'm still in problem. I have a minor kids, school going student.
Okay, right.
On any condition, kindly, so that my attendance may be secure.
We can direct the trial court to,
We did.
expedite the trial.
My lord, on any condition. Because prima facie, my lord, as per the deposition, prima facie, I have made out a case.
You might get a chance, but right now we do not know. You might get a chance later on for whatever order,
no,
but
for
right
fair-
now,
At
there's nothing
at
to
least,
show.
my lord, for fair trial,
Heard Mr. N.K. Mari, learned counsel for the petition. Also heard Mr.
RR Kaushik,
R.R. Kaushik, learned counsel for, learned
additional.
addition PP. The petitioner who had been arrested on 22/7/2022, is it? Is the date correct?
37.
Huh?
37.
Who had been arrested on 37/2022 in connection with this recovery of 26 kgs of ganja. In Lumbing PS case number 127/2022. Under section 20 B2C,
20C, my lord.
huh?
C.
20C.
How much?
Show me 20C, 20C. Give me the NDNPS Act. 20C of the NDNPS Act. Is praying for bail. On the ground that while charges had been framed against the petitioner on 3/2/23. Only 4 out of the 9 prosecution witnesses have been examined so far by the learned trial.
4.
4 out of the 9.
4 out of the 9.
The next para, the learned counsel for the petitioner submit that in terms of the judgment of the Supreme Court in the case of Dash versus Dash 1984, 1 SCC 284, and in the case of Dash versus Dash reported in 2023 live law bracket SC slash, no, comma, not comma, 260. The petitioner should be released on bail. Puspa. He also submits that the 3 prosecution witnesses have been examined by the learned trial court, and their evidences do not point towards the guilt of the petition. So accordingly, bail should be granted to the petition. The next para, the learned additional PP on the other hand submits that there is no delay in the trial proceeding. And as the drugs have been recovered from the petition, the petitioner cannot be released on bail unless section 37 NDNPS Act. Unless the conditions imposed under section 37 NDNPS Act is fulfilled. That's all.
Yes, sir.
He accordingly submits that the bail application should be rejected. That's all. It actually. Where is the? It cannot be 20C as such. It should be 20B2C. That is the wrong provision. I have heard the learned causes for the practice. The petitioner having been arrested in connection with the recovery of 26 kgs of ganja. The petitioner has to be charged under section 20B2C NDPS Act. Question. In any event, mere mention of a wrong provision of law does not invalidate any order, when the correct provision of law is in existence. Full stop. Next paragraph. As can be seen from the order passed earlier in bail application number 2787/2022. Consideration of charge was to have taken place on 3/2/23. As 4 prosecution witnesses have been examined out of 9 prosecution witnesses. There does not appear to be any delay in the trial proceedings. Further, in terms of section 37 of the NDPS Act, bail can only be granted where the court is satisfied that there are reasonable grounds for believing that the petitioner is not guilty, that the accused is not guilty of the offense. And he is not likely to commit any offense while on bail. Next paragraph. In the present case, the trial not having been completed, it cannot be stated that there are reasonable grounds for believing that the petitioner is not guilty of the crime. Further, the case relied upon by the learned counsel for the petitioner in Bhagirat Singh Supra. Bhagirat Singh, son of Mahipat Singh Judeja Supra, is not applicable to the facts of the case, as the said decision was with regard to an application for bail made under section 439 (2) CRPC against the charge made under section 307 IPC and section 135 of the Bombay Police Act. The judgment passed by the Supreme Court in Mohammed Muslim alias Hussein Supra was with regard to the accused having been in custody for around 8 years, and due to the trial not having been concluded, it was in that context that the Supreme Court had held that refusal of bail on the one hand and to delay trial of cases on the other was clearly unfair and unreasonable and contrary to the spirit of section 36(1) of the NDPS Act. Section 309. CRPC and Articles 14, 19, and 21 of the Constitution. In the present case, though there is some delay in the trial proceedings, it is seen that not even 1 year has passed from the date of consideration of charge. In view of the above grounds, this court finds that the case of Mohammed Muslim Hussain, alias Hussain Supra, would not be applicable to the facts of this case. As the two cases have different factual, have different fact situations. The application for bail is accordingly dismissed. However, it is hoped that the learned trial court shall expedite the trial proceedings in NDPS case number 123/2022 and dispose of the same at the earliest.
Finally, one line may be added, madam, in my submission, that there is no prolonged incarceration of the petition.
Mr. Madhya said, the additional PP also submit that there has been no prolonged incarceration of the
Petition.
petitioner, as he has been in jail for only 1 year, 2 months, as on date. Let's see, you might get acquitted in the trial, we do not know.
That's it. I have to try my luck in the again. I'm a pleasant.
Sir, di ba, yes, no, submit ko siya na ito. Di ba?